Welcome to Epstein, Becker, Green's webinar, Healthcare Fraud Investigations, What to Do When the Government Knocks. We have a housekeeping slide that lets everyone know that the participant phone lines are on mute. You can also use your computers versus a phone. The slides and recording will be distributed after the webinar by email link. Question and comment should be typed into the Q&A panel, and if you lose your internet or phone connection, please redial in. Before we begin today's presentation, please be informed that the webinar is being recorded. You're also welcome to submit questions directly to the presenters following the webinar, and contact information will be displayed at the beginning and end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein, Becker, Green will communicate the availability of the webinar recording and access to the PowerPoint materials. At this time, I'd like to turn the webinar over to Marcia Nusgart, Executive Director for the Alliance of Wound Care Stakeholders.
Lisa, thank you so much, and good afternoon, everyone. We are so pleased to be able to have Epstein, Becker, and Green, George Breen, David Matyas, and Lynn, Shapiro, Snyder, members of the firm, presenting today's webinar, along with myself, for the Marcia Nusgart, Executive Director for the Alliance for Wound Care Stakeholders Moderating, which is myself. And I welcome many of the members that are members of the Alliance of Wound Care Stakeholders, and I wanted to show a few different slides for those of you who are not familiar with who we are. We are a nonprofit multidisciplinary trade association of physicians, specialty societies, and clinical associations whose members treat patients with wounds. So therefore, we're really an umbrella organization for these clinical organizations, and the mission of the Alliance is to promote quality care and access to wound care products and services for people with wounds. So what do we focus on? It's really areas of commonality of the organizations in reimbursement, government, and public affairs affecting wound care. So again, as I just mentioned, with wound care being multidisciplinary, here's a list of the broad spectrum of clinical associations who are our members in this area. But not only do we have these clinical associations members, we also have non-clinical associations such as wound care clinics and also manufacturers, all of whom are very important, to the Alliance. So you wonder, what are the foundations of the Alliance work plan? What do we work on? Well, wound care quality measures, wound care research, and really the bread and butter issues, which are reimbursement issues, because we have our leg in both camps, both in the fee-for-service side of things as well as implementation of the Medicare access and CHIP reauthorization, otherwise known as MACRA. So we present comments to federal agencies and their contractors and speak at their meetings. It's not only the Medicare Centers for Medicare and Medicaid Services and their contractors, but also AHRQ, FDA, and we serve as a resource to these agencies about education on wound care. So what was interesting was that in talking to many of the Alliance members, we were wondering whether any of our members had ever been involved in a government healthcare fraud investigation or audit, and wow, would they know what to do if an FBI agent were to visit them in their home? And many of them said, well, we're not really sure of that. So what we did was we thought it was very important for the Alliance of Wound Care our members and also those within their associations learn more about this. So we reached out to our friends at Epstein, Becker, and Green, who are experts in this field, to be able to put on this particular webinar. So we really appreciate this. I'd like to start off with introducing Lynn Shapiro Snyder, who's going to be addressing this, and she's going to go over the agenda with the current regulatory environment for fighting healthcare fraud, enforcement trends, recent settlements and decisions, the overview of the False Claims Act, the types of government touches, the mitigated risk, and any questions and answers. So let me turn it over to Lynn. Thank you so much.
Marcia, thank you for having us today. We really appreciate the Alliance taking the lead here in trying to get more education out to the world on this very important issue. In addition to this PowerPoint webinar, we also authored an article in the August 2016 Today's Wound Clinic on responding appropriately to government inquiries. So let's start with the current regulatory environment for fighting healthcare fraud. First and foremost, the federal government is rapidly expanding its role as both the dominant payer and the dominant regulator of healthcare goods and services. You see some of the acronyms here: federal employees, the Veterans Administration, the CHIP, which will be reauthorized soon, Medicare, TRICARE, and Medicaid. But how much is the government really involved? So first and foremost, I wanted to spend a very short time showing you what the baby boomers look like in becoming Medicare eligible. I don't know how many of you know that both former Presidents Bush and Clinton are literally the baby boomers. They were born 6 weeks apart right after World War II and 10 months later. And we used to add 500,000 Medicare people a year based on birthday, and we're now going 1.2 million, 1.7 million at a 45-degree angle for almost a 35-year period. And it's not just Medicare fee-for-service that's growing. A disproportionate amount of the younger Medicare population and some of the chronically ill are joining the Medicare Advantage plans. And I want to make sure the audience understood there's really a misunderstanding in the marketplace of what is Medicare Advantage, because very often it'll have names like Aetna or commercial payer names. And when you go to enter them in your accounts payable and your accounts receivable system, very often the financial class or the financial service code that the payer is put under is a commercial payer code. But these are really plans, these receivables need to be treated no differently than the Medicare fee-for-service. Whether you're in a managed care contract or not, it's still considered federal money. And I think people really make that mistake. And if there's a few little tips, that would be a big tip to take back. So the secret of the Affordable Care Act is that Medicaid grew. That's the main way that the Obama administration was able to reduce the uninsured from 50 million to below 20 million. Even though the Supreme Court made it optional for the states, a lot of traditional Medicaid people found Medicaid in addition to the new Medicaid eligibles. And of course, Medicaid is predominantly in these managed care companies, whether it's companies like Molina or Centene. Once again, if you don't have them registered in the financial classification as government, you're already at a disadvantage because all of this should be treated as government. So who are the government agencies who are actually the enforcers? Those were the payers for the claims. Well, first and foremost is Department of Justice, the Office of the U.S. Attorneys. This is, in essence, the law department of the federal agencies. The Federal Bureau of Investigation are the investigators to help the lawyers do their jobs. And then even the Department of Health and Human Service has their own inspector general. I call them the policemen of the government programs. The audit services, sometimes they're going to do an audit and they find a problem and then they send it over to OIG. We also have Office of Civil Rights, which also is the main enforcer for the privacy and security laws. Office of Evaluation and Inspections, which does study whether the government money is being spent well. And within the Center for Medicare and Medicaid Services, which is the bill payer and the overall agency, is Center for Program Integrity, which is an arm of just the regular Medicare program that does its own analytical understandings and looks for trends in improper expenditures. So sometimes the government creates these task forces, so they pool together resources, and then they get credit if they get a case in that segment. The HEAT is one example, the Medicare Strike Force another. Many of you may have heard hospice was a target of some of these fraud action teams, and sometimes it makes it harder to deal with those cases because Main Justice plays a disproportionate role, not the regional offices of the U.S. attorneys. So you can see the money is coming in. So on the federal enforcement efforts against fraud, we thought it would be helpful to see some metrics that show $1.98 billion in judgments and settlements. The U.S. Attorney's offices opened over 900 new, and we're emphasizing criminal health care, not just criminal, but criminal health care cases. In the old days, a mistake was civil fraud was criminal. Now, every case has to be started. You start criminal, and then you have to get to civil. And then, as the last column, we had 600 defendants convicted, and we had over 4,000 individuals excluded from future participation in Medicare and federal government programs. On the exclusion side, some of that does come from the enforcement actions, but some of it also comes from the failure of the people to pay their student loans. And people don't always know that, but it's a big issue for healthcare professionals. And it is a law that before you hire somebody that you check to make sure they're not on the exclusion list. And a lot of companies forget to do that on the HR side. And then there's a real question whether the government receivable is a legitimate receivable when it's generated by somebody who's otherwise supposed to be an excluded individual. Okay, so the bottom line here is, why are there so many people working on healthcare fraud enforcement? Is it worth the time and effort? And the answer is, oh boy, it really is worth the time and effort, because the average return on investment over the last 3 years is for every dollar spent, they're getting $6 back. And those of us can understand the motivation here. One, you want the public fisc money to be spent efficiently, but also you want to show deterrence, and you want to be able to show that people are afraid to do the wrong thing. If they think they can get away with it, then they're more likely to do it. So George, take us through some more details all about this fraud enforcement and why it's worth the time and effort. George, are you there?
If we turn to the next slide.
We're on page 19.
Great, thank you. One of the things that Lynn had mentioned was the issue relative to the Medicare strike force and the HEAT task force. What folks may not appreciate is, in particular as we relate to the strike force, the government has already told us that it anticipates that there is effectively a 75% increase in the numbers of individuals who have been charged with criminal health care fraud allegations since the strike force was first initiated. And while the HEAT strike force and the task forces are ones that you often hear about in the news, what folks don't tend to focus on is the Healthcare Fraud Prevention Partnership, which, if you're interested in finding information about it, it's at hfpp.oig.gov. People often ask, well, do the federal payers and the commercial payers share information? The Healthcare Fraud Prevention Partnership is a creature of the Obama administration to allow, on a voluntary basis, representatives of the federal government, state and local governments, and private insurers to collaborate, to share information relative to claims histories, for example, to see if they can identify claim outliers, to see if they can identify different claim submission patterns. For instance, does a provider submit to a commercial payer a claim that is different or in a different manner or fashion than it would to a federal government payer? And so when people ask if there's an opportunity for, if there is actually a sharing of information between the feds and the commercial, the federal government and the commercial payers, the reality is that there is, and that there is, in fact, a mechanism in place to make that flow of information more expeditious. The OIG has testified before the House Ways and Means Committee that this has allowed it to identify on a more specific basis areas where it thinks that there are potential weaknesses in the system, that this partnership has allowed it to identify specific areas to go after from a geographic perspective, particular practices to go after from a professional perspective, and people need to be aware of this partnership, and they need to recognize that there is this sharing of information. The reality is also that the notion of paying and then chasing purported improper conduct is one that the government recognizes has not been particularly successful. So much more money and time is spent at utilizing predictive analytics to analyze data, to look at information, to determine if there are patterns or issues that the government can identify simply from a review of the information that you are supplying to it, rather than having it go out and actually try to reach out and pursue an affirmative, open, active investigation. When we talked about a few slides ago the notion of a recovery based on a 3-year return on investment, the government has told us that using predictive analytics, it's saving $1 billion or more every year, and is a return on investment of $11.60 for every dollar spent. You cannot, the government has no way to be able to recover that level of return, which is why, again, you have seen so much about the effort to pursue healthcare fraud. If we turn to the next slide, we'll talk about an issue that has come up, which, particularly from a compliance perspective, is one that folks need to be aware of. In September of last year, Deputy Attorney General Sally Yates published what has been affectionately referred to now as the Yates Memo. And it's a memo that addresses the issues of individual accountability. The government has long taken the position that focusing purely on corporate conduct was not sufficient to change conduct. The notion that it would continue to pursue corporations didn't address what it considered to be the root cause of the problem, which was the individuals associated with those businesses. So in the government's view, while it would tell you that it has consistently focused on individuals, what I will tell you is that this is a focus that is in fact a significant change in where the government has been. And what it is a memorandum to prosecutors across the country, both civil and criminal attorneys in the Department of Justice, about what expectations the government has as it relates to focusing on individuals as part of an effort to look at individuals from the virtual inception of the investigation. No longer is it that you look at individuals as an afterthought, that you look at individuals only if you think that there is some ability to pay. In fact, what the government tells us now is individuals will be looked at from the inception of the investigation, that both the criminal and civil sides of the Department of Justice will coordinate, will collaborate. They're expected to share information, and they should be in routine communication with one another as a part of this effort. If we turn to the next slide, you'll see that in addition to the sharing of information between the civil and criminal folks, there is, absent extraordinary circumstances and sign-off by the relevant U.S. attorney or the Attorney General, there will be no release of an individual from either civil or criminal liability as part of any corporate resolution. The government expects that corporations, to obtain any cooperation credit, corporations must produce to the government all relevant facts. They expect and assess that as being what a company should produce if it expects to have credit, and expects that sharing of that information to be timely and to identify individuals who are responsible for the conduct regardless of their seniority. And the government will no longer look at the notion of whether an individual can pay for a civil judgment in determining whether on the civil side they'll pursue an individual. So when you have folks in your organizations that say they're really looking at the corporation, they're not looking at me, we will tell you that that is no longer the case, and the Yates Memo really gives, particularly for the compliance person, the effort to focus individuals on making sure that they recognize it is in fact about you. If we turn to the next slide, what you'll also see is that there's a focus on compliance not only on the civil side, which has been traditionally so, but also the criminal side. In November of this year, the Criminal Fraud Division of the Department of Justice hired Huey Chen as its compliance expert. She will now be involved in criminal investigations from their inception. She will look at and assess an organization's compliance function, both before an allegedly bad act, after an allegedly bad act, and following a resolution with the criminal division. So she will be following it to make sure, for example, if there's a resolution that's reached with the organization and the Department of Justice, whether or not the organization is in fact fulfilling its obligations under that agreement. In addition to what compliance officers always worry about, the seven sentencing guidelines and OIG's guide to corporate compliance, you also should be recognizing that Ms. Chen has told us that there are specific areas that she will look at as part of her assessment, which includes training, whether or not the organization is actively auditing or monitoring, and whether the organization has demonstrated throughout its organization that it is serious and takes compliance in a priority matter and has devoted the correct dollars to be able to invest in compliance-related activities.
George, this is Marcia Nusgart again, and you know, the slide that you just were mentioning might be the most important and relevant to the wound care practitioner and the hospital wound center. It's asking if the hospital has thought about the highest risk area for wound care, which is debridement or debridement, as some people call it, and hyperbaric oxygen therapy. It's asking whether the monitoring and auditing is effective. So how can the hospital really know that? Well, they need to have auditing in place to address each of the items specifically listed on the OIG reports pertaining to hyperbaric oxygen therapy and debridement. Specifically, is debridement being billed at the level and documentation can support? Do they have a monitoring plan in place for that? Are they ensuring that non-debridement services are not being billed as surgical debridement, such as callus pairing? And is documentation of debridement adequate, such as chart reviews? So in regard to hyperbaric oxygen therapy, one needs to question, are they monitoring to ensure that they're not billing Medicare for non-covered conditions? Is documentation adequate to support medical necessity of hyperbaric oxygen therapy? Are patients getting only the number of hyperbaric oxygen therapy that they need? Are they performing the appropriate tests before they use hyperbaric oxygen therapy? And finally, is a physician in attendance as per the requirements? So the hospital really needs to be monitoring this, and it's a really effective monitoring. We should know what they're doing. Is there evidence that they're monitoring at all? Since the Department of Justice told us that debridement and hyperbaric oxygen therapy were the two areas that they were most interested in, these are the logical ones to focus on, even though they're not the only ones. There's even some other such matters like compliance with the provider-based rules for billing, et cetera. So let me also turn it now over to David Matyas that's going to address the section on enforcement. David?
Marcia, thank you. So if we go to the next slide, you see, and we'll come up to this again in a little bit, is the OIG, as one of the enforcement agencies, doesn't really hide the ball. They tell us at the beginning of each year what some of the priority issues are and what they're going to be looking at. And wound care has been an issue in the past, and in 2016 included within the OIG's work plan. Specifically, they've informed us that they're going to be looking at the billing compliance issues, and they're going to be looking at the audits and investigations that have occurred over the last few years, seeing noncompliance as what one would consider just Medicare billing requirements not being met, now rising to the level of being considered fraudulent. And what the next slide shows with some recent settlement decisions and actions is the fact that this, over the last few years, for wound care has become a significant issue. Going back to 2013, you see here, the first bullet is showing that a whistleblower brought an action alleging that hyperbaric treatment providers were falsely submitting claims to the government, certifying that that they were provided under the direct supervision of a physician and that the physician was immediately available. The whistleblower alleged that the physicians weren't on site. Interestingly enough, we know that the government declined to intervene in this particular action. The whistleblower still moved forward with that action, and I'll talk about that in a moment, how that can actually occur. But in the end, this matter basically disappeared in the wind with very little credit being given by anybody, including the courts, to this theory that was otherwise being elevated by a whistleblower. Doesn't mean that the government doesn't take seriously the need for there to be direct supervision by physicians, but it shows that when a whistleblower who was not involved, did not understand the intricacies of how Medicare billing requirements exist in a hospital setting versus a physician office setting, the government will actually listen to the defense counsel and listen to understanding how the rules and regulations apply differently depending upon the different settings. The second example that we're giving you is of a particular organization that did enter into a settlement agreement under the False Claims Act, where there were allegations that they were billing for manual lymphatic drainage therapy, that instead of physical therapists who are required to be providing the services, the providers were basically using massage therapists. So the use of unqualified therapists is a significant issue, and for a particular organization resulted in a $4.3 million settlement on the civil side, but also resulted in the individuals involved, the owners of the company, being excluded from future participation in the federal health care programs for a minimum of 10 years. The most recent example, which has been getting a lot of attention these days, is a whistleblower action that recently was unsealed, where there have been allegations that selective debridement was actually being done, but upcoded to surgical excisional debridement, which is otherwise a pricier and more expensive procedure. There were also allegations that medically unnecessary HBO sessions were being provided because of misdiagnosis or false diagnosis of pressure ulcers actually being considered diabetic ulcers. What I also know is that in this matter, there's claims as well that there were medically unnecessary transcutaneous oximetry testing being done, and again, there's this whole host of allegations that have been alleged. No wrongdoing has been found. No one has agreed that the company involved has engaged in misconduct. But what's important for those to know on this phone is it's multiple layers of providers. It can be a hospital being the target of the investigation. It can be a manager of wound therapy centers being the target of the investigation for causing a claim to be submitted. It can be freestanding. It can be hospital-based. This area is a significant issue, and I think we're going to be seeing more of it. Let's move on to the next area, which is, as the slide before was telling you about the settlements, we were mentioning False Claims Act. The target of most investigations in the statute that is used is the Federal False Claims Act. And what this statute basically prohibits is any person, that definition of person can be an entity, knowingly presenting or causing to be presented a false or fraudulent claim for payment or approval, or making, using, or causing to be made a false record or statement material to making a false statement, and that person then is liable currently for $5,500 to $11,000 as a penalty per claim, plus treble damages. I believe it's scheduled for increase in October. The minimum penalties will be increasing significantly based upon some modifications that the federal government is making to the imposition of penalties, these amounts can be staggering. And that's why when you're dealing with the million-dollar settlements that occur, when you look at the violation, which is the submission of the improper claim that the government paid, the government can get up to 3 times that amount that was paid, plus for each claim that was submitted, a civil penalty on top of that. That's how in the healthcare context, when there are thousands upon thousands of claims that a provider could be submitting on a daily, weekly, monthly basis, can turn into damages of the millions of dollars. An important issue here is the last bullet, which is the, in legal jargon, scienter requirement, is not that you actually really knew that you were physically presenting a claim and that you knew it was wrong, but the knowledge requirement here is that you knew or should have known, or you acted in deliberate ignorance, or the real significant one here is you acted in reckless disregard. So the government can bring an action under the False Claims Act for knowingly or causing to be presented a false claim merely because you do not do your diligence. You don't necessarily train people the appropriate way. You don't necessarily use qualified individuals to do coding and billing. So the level of knowledge is not what a layperson might think of in knowingly engage in an improper act, but is much broader and indeed is what's used by the government to attach to many of these investigations. But what the next slide also is important to know, and why the False Claims Act is so significant, is because most of these actions these days in healthcare are not because the government has proactively started its own investigation and brought its own lawsuit seeking damages under the False Claims Act. But the vast majority of these matters are initiated because the False Claims Act allows for whistleblowers, or the legal jargon is a qui tam relator, which basically allows someone in their individual capacity to bring a lawsuit on behalf of the federal government in order to indicate that violations of the statute have occurred. And the whistleblower is entitled to between 15 to 30% of the amount recovered. So when there's a settlement for $10 million, somebody who was the whistleblower may be receiving between 1.5 to 3 million of that settlement, depending upon their level of involvement. What's interesting is, and as I alluded to earlier in one of the examples, when an individual brings a lawsuit on behalf of the government, the Department of Justice is then informed that this lawsuit has been filed. The Department of Justice then begins its own internal investigation, and then it decides whether to intervene in the action itself. The government in many situations will decline to intervene, but that doesn't mean that the whistleblower has to stop there. In fact, there's many whistleblowers who, even though the government has said that they don't believe that there's a significant violation or enough reason to pursue a claim, will still continue on with the action, which is how and why whistleblowers will get on the higher end of that percentage if they themselves have not, if the government themselves have not otherwise intervened. So the False Claims Act is very significant, and here is, on this slide, categories of how the Federal False Claims Act is used in typical situations. First, you see inadequate documentation of services being performed. So even though a service may be performed, as the federal government says, unless it's appropriately documented, it shouldn't be paid for, even though it may have been medically necessary. So dotting I's and crossing T's are very important in order to ensure safety under claims under the False Claims Act. Billing for services that are actually of such poor quality that they're deemed worthless has become a new and more novel theory over the last decade, much more successfully, that when services are so poor and improper that actually the government never should have paid for it. The notion of false certifications being made by providers, the physicians themselves, that services were medically necessary, from hospitals when they're submitting their documentation certifying that the claims are being submitted correctly, all can result in False Claims Act. Billing for goods or services that were never provided, that in my mind becomes the more obvious areas of fraud. When something isn't actually provided and you're billing for it, the government will take exception with that, which leads into the next, which is billing for medically unnecessary services. And when we get to the last one, which is upcoding, which we've talked about and will continue to talk about, is when you bill for a service that's actually performed at a lower reimbursement level, but upcoding it and charging more is where and how the government has been bringing many of these actions. So, Marcia, can you take us through how some of these False Claims Act examples have really fallen into line with the enforcement activities within wound care?
Thank you, David. Well, as mentioned earlier, that I said one needs to really look at hyperbaric oxygen therapy as well as debridement. In terms of hyperbaric oxygen therapy, the two areas are certifying attendance or direct supervision by physicians when there are actually no physicians present. And then secondly, falsely diagnosing to qualify for hyperbaric oxygen therapy coverage. And that's really very significant also. In terms of debridement, as you just mentioned, upcoding is very important, as well as inadequate documentation of services provided. Both are extremely, extremely critical, and those in the wound care community need to pay special attention to that.
So this is Lynn Snyder. The OIG provided reports on areas of concern over a decade ago. You heard David Matyas say that they don't hide the ball, but sometimes they'll publish it. Not everyone reads it every year, and then it has a life of its own, and it takes years before the cases come forward. But these areas are not new to the OIG, and it means they're also not new to the Department of Justice. So on this page, we've included for you some of the older OIG reports. If you notice, the links say OEI, that was the Office of Evaluations and Inspections. These are where they're studying the issue. They see something that's not quite right. And this would be the kind of page that, as a compliance officer, you would want to make sure in your work plan that for auditing and monitoring on a going forward basis, I know sometimes you're in a major hospital system and this area of wound care may not get the priority, but sometimes showing the powers that be that determine prioritization, that these are topics that are front and center with the government, is the best way to get the prioritization you deserve. So we've given you the list of the top compliance issues on both of these two areas of wound care. And we recommend that you take a look at those reports in order to get more details and might help you shape your audit. Okay, let's go to section 4, and George is going to take us through the types of government touches.
Thanks, Lynn. So if we turn to the next slide, what you'll see are, and unfortunately, there are a variety of ways in which the government can reach out. And the significance here is that employees need to be sensitive to the notion of the many ways in which the government can attempt to secure information. Some of them are more frequent and more common than others. Certainly a subpoena from the Office of the Inspector General requesting documents, a subpoena issued by a grand jury asking that certain documents be produced ought to be triggering in your mind that there is a potential criminal activity, whether there is activity directed at you or whether it is directed at someone else but with whom you may have information or have business dealings, is something that needs to be ascertained at the beginning. Remember, too, that if you receive an OIG subpoena, the OIG operates both civilly and criminally, and so there needs to be an appreciation within your organization that there are significant issues associated with the receipt of information, of subpoenas in this fashion from the government. The civil investigative demand is one that's frequently used now by the Department of Justice as it is investigating False Claims Act cases while those cases are under seal. It allows the Department of Justice the opportunity to request documents and to ask that individuals appear for deposition, or that interrogatories, written questions that are to be answered under oath, be addressed to the organization. It allows the company, it allows, in fact, the government to conduct discovery, which would otherwise take place in a civil case during the normal course after the defendant had been served with a copy of the complaint, to conduct pre-service discovery. And it's significant because it's information that can be shared with the qui tam relator, as David discussed earlier, and it's information that the government then has available to it as it decides whether or not it's going to intervene in a False Claims Act case. Certainly in terms of the more serious government touches, our search warrants, it's critical, of course, to have individuals understand what the government's rights may be relative to the execution of a search warrant and what the individuals in the organization's rights may be in relation to that as well. Or there is a sensitivity that employees ought to have that if they are approached by a government agent as part of a search warrant, that it is their right to speak to that agent and it is their right not to speak to that agent. It is their right to have counsel be with them as they speak to that agent. And part of the compliance function in the organization ought to include a detailed description of the types of government touches that could be impacted here. And again, it doesn't mean that the organization has or has done anything wrong, but the reality is individuals need to be prepared for the myriad of ways that the government can approach them and be prepared to address that. As it indicated at the bottom of the slide, there are instances when government agents will approach individuals at home, in the parking lot of the supermarket, as they enter the office building in that morning, as they ride the elevator to the floor that they work on. And individuals need to be sensitive to the notion that this could happen and be prepared, and there should be policies within the organization which specifically address how to respond to the government touch. If we turn to the next slide, what's critical here is that there is a practice and procedure in place for responding to communications from the government. They should all be taken seriously. Certainly if you see subpoena on any of these, on a government communication, that needs to be taken seriously. But there needs to be a process in place whereby individuals associated with the organization recognize that this is the process that we follow each time that there is a government touch. There is a conduct a fire drill is one of the recommendations you'll see in the slide. That means don't wait until you actually get a subpoena. Don't wait until the agents come through the door seeking to seize information from your offices. Have a fire drill so that people understand how this would actually play out. And make sure that individuals understand what their specific roles and that those roles should be memorialized and the procedure should be consistent each time, because that is the way that the organization is best able to protect itself. Lynn, I'll turn it over to you now to talk about some of the tips that individuals and organizations can consider as they try to mitigate some of the risks that they face with healthcare fraud enforcement.
Okay, we're on mitigating risk. We're going to go through 6 different tips. Before I get to tip number 1, I just wanted to mention one of the things that I do is I advise companies even at the board level because compliance officers should be reporting, have at least a dotted line reporting to boards of directors. Boards of directors are very interested in risk mitigation. That's part of what their job is as a fiduciary of the company. And It may be that in some of these tips that we're talking to you about, it's more employee-oriented, but there are other tips that we can advise you on in terms of how to educate and make sure your boards are involved in helping to mitigate the risk. Okay, tip number 1, be sure all your employees know how to respond to all types of government inquiries. Now, George listed a whole bunch of stuff. Years ago, when we would do compliance training, the companies were reticent to train their employees on what to do because they thought that if they were talking about the government coming to their doorstep, that people, the employees, would get nervous that maybe it meant that the company was doing something wrong and they were just trying to cover it up. And those days are over. The fact that you receive Medicare and Medicaid money, even if you are the most compliant company around, does not negate the fact that you still have to train people what if they are touched by a government inquiry. So we have some practical issues that we've included here. First of all, compliance officers know that one of the best tools they have are these little wallet-sized employee hotline cards. They're like folding cards that will have on one side the hotline, and on the other side, if you are contacted by a government person, please call, and it may be the general counsel, and it may also be the compliance officer's direct dial, but it has other instructions on what to do. People don't always know that FBI agents have a business card. They're always surprised when I'm doing the training to hear that government people have business cards. And you tell them, get the business card, you're happy to cooperate, but your company policy is to get the business card. We're going to talk to the company officials, and we'll get back to you for a more reasonable time when we can have an appropriate interview. Sometimes people are afraid to just ask, what is it about? But it's helpful to ask, what is it about? Because 9 times out of 10, it's not about your current employer. It's about your former employer. And that's because the government has more latitude to get information from you when it's about a former employment relationship than a current employment relationship. And even if it's about a former employment relationship, you should contact your current employer for advice and guidance on whether and how to notify your former employer about the touch. So why is this important? Because I can guarantee you that the entire way in which the company is appropriately addressing that government inquiry will be improved significantly if your employees understand the first touch. An entire strategy sometimes has to be about how to rectify problems that occurred when the first touch was not addressed adequately. And we have found, especially with physicians, they love this training because it improves their morale. They feel more confident that they know what to do, because doctors will say, just tell me what to do. I just want to know what to do. If an FBI agent comes to my house on a Sunday night, just tell me what to do. So we have found that physicians in particular love this type of training. They just want to know what to do. Tip number 2. So it's not enough to do just training. The training has to be quality training. A lot of you use computer-generated, 20 questions. They do it at home or on weekends, and then they check off the box. Unfortunately, you do have to do it that way in order to check off the box that everybody got the minimal amount of training. But I must tell you, nothing replaces an in-person meeting. First and foremost, make sure here are some of our practical tips on page 39. Train at the level of the audience. Every audience needs a different, you have to know your audience. It may be a lot less legalese and a lot more practical stuff because you're dealing with the receptionist or the people in the mailroom, whoever it is, they all need to be trained. And then it doesn't have to be a whole hour. There are these new, people have attention deficit, short versus long, a 15-minute, let's talk about this topic this week. And frequent changes in regulations are a great time to also include compliance training, because you have to get the content out anyway about the change in government regulations. And then it is very important to demonstrate that attendance is a priority, and it helps to have the CEO and the senior management team sitting in the room at the same time the junior-most people are there, even though it helps to show the commitment that way. A few more training tips. People listen differently. Very important to have video, more important than ever before. Interactive sessions, computer-based, the one-on-one, the coffee break training, and quizzes. You have to document comprehension checks, and so having questions afterwards is very important. Some of the times that people don't check the answers when they get them wrong. I've also found that when I've done training like this, I learn more by going to the restroom during the breaks, when people will come up to me and ask me the difficult questions because they don't want to raise their hand in the group setting. So please think about how effective your training really is. And on page 41, why? Because it decreases the likelihood of whistleblowers. It creates frequent opportunities to have just any face-to-face discussion, let alone compliance. Maximizes the employee's understanding, ensures that everybody remains current, and the bottom line is the employees want to work for a company where there's confidence that the company wants to do the right thing. And the best way to show that is to make it an area of openness, so if they think they're doing the wrong thing, they're going to tell you about the dirty laundry before they go running to a third party to tell them about the dirty laundry. George, take us through the next couple of tips, will you?
So tip number 3, coordinating compliance with human resource activities. I think that's one of the things that folks don't spend enough time recognizing, that there is real information and value that can be gathered by having some level of coordination between compliance and HR. The idea that HR is conducting exit interviews with individuals becomes an opportunity to really understand whether there are issues that are going on in the company that the compliance officer ought to be concerned about. And so individuals associated with the Human Resources Department ought to be trained to and be asking compliance-related questions, to be able to share that level of information with compliance, particularly when you have a situation where there are disgruntled employees that are going to HR. There is a school of thought which is that the whistleblower wouldn't be the whistleblower had he, she, they, it not gotten a positive response from the organization that they were working with at the time. And so the notion that compliance can identify and can learn from the Human Resources Department identification of individuals that have concerns about the organization to see whether there's any merit there one way or the other is a real benefit to the organization, because you want to try to take whatever efforts you can to avoid the concerned employee from taking that next step and going to the government, rather than speaking about the concern internally and seeing if there is an internal solution that can resolve and can prevent the notion of a whistleblower claim. The other thing, as was mentioned earlier by Lynn in the presentation, please make sure that HR, if HR has that function, is conducting a monthly exclusion check to make sure that the individuals that the company is employing are not barred from participation in federal health care programs. Tip number 4, if we turn to the next slide, talks about the need to develop and track a budget for compliance activities. The reality is that as the government's looking at your compliance program, it's going to want to make sure that it's a real program, that it is more than just paper, that it is more than just word of mouth. One of the realities is that the government's going to want to know what the resources are that the organization is developing and participating and contributing to compliance. Are there significant funds that are being devoted to the compliance function? Are the individuals who are in the compliance department appropriately of an appropriate stature? Because the government takes the notion of compliance and the resource devoted to compliance very seriously. You cannot expect to show the government that you are conducting a rigorous auditing and monitoring program without funds sufficient to support the program. So there really needs to be care taken as that budget is developed, and that means education to senior management about the notion that while compliance is not a profit center or line item, there is a significant need to make sure that funds are sufficient so that when you're questioned about the sufficiency of your program, you can use this as an advocacy for why your organization is striving to do the right thing through its compliant function. David, can you take us through the next 2 tips?
Sure. In the time we have remaining, and then it's time for questions. Tip number 5 gives us that you need to be thinking about compensation methodologies and the impact it has on ensuring compliance business behaviors. So the next slide really kind of walks us through some of the practical issues. The last thing that we're saying is that you should not have employees receiving commission-based compensation. But you need to think twice about what you're otherwise promoting and ensuring, and that you're otherwise putting some safeguards in place that the government isn't going to basically be coming back to an organization saying that your commission structure, your incentive-based compensation was pushing people, incentivizing them, encouraging them to engage in improper conduct that resulted in the submission of improper claims. So there's a number of tips that we're trying to provide you with here, which is, first of all, think about how within an organization bonus and commission structures can also have an overlay of ensuring quality, that there's consumer retention and satisfaction issues, that it's not solely about the increase in revenues that an individual may have helped contribute towards, but that there's other overall factors to think about. You also need to think about how a compliance officer's compensation is structured. Many people think, well, how can a compliance officer receive any incentive compensation? Well, the effectiveness of the compliance program is one of those things that they should be evaluated on and compensated on. If you have an organization that has a hotline but no one calls into it, means that the compliance officer is not necessarily doing their job in promoting the fact that there is a hotline. How often are training programs occurring? How adequate is the documentation? What kind of auditing is being done? There are plenty of ways to incentivize compliance officers to be doing all of the right things as part of their job and to be able to incentivize them that way. So the last bullet here, money and behavior should promote the same compliant goals that are set forth in the written policies and procedures. And I think that's an important concept, that money talks, but money can also talk to really make sure that an organization is doing the right things. Tip number 6 is that an effective compliance program that adds value to an organization requires not only written policies, nor just well-informed people, but it requires both. And that you really have to have these things go hand in hand. You have to have the written policies and procedures. As defense counsel, we need to be able to show those things to the government when they come knocking at the door. But they also need to be able to show that employees know what to do and what not to do. And very often, the government, when it comes in to do their investigations, and they hear how an organization acts in a compliant manner by training their people, they take that very seriously. The next slide basically summarizes these 6 tips. Once again, it gives us now an opportunity to go into a few questions. And Marcia, the first question that came in, I think, was directed directly to you.
Yes, it was. Was stated, will the wound care industry survive all this government scrutiny? Well, it really goes back to the fact and the point that the government is the payer, and one has to realize this. And of course the wound care industry is going to survive. It's going to thrive because there's a perpetual need for innovative and effective wound care solutions. The only point we're making today is that all stakeholders in the industry need to invest time and resources focused on compliance in this area. And that's really why we brought this webinar for you today, that we want to be proactive in this area. And I also want to remind you, those who do subscribe to today's wound care clinic, please read more information in the August edition of this, and you'll find a great article from Lynn, Shapiro, Snyder, George Breen, and Matyas, who we definitely want to be able to thank today, because without them we wouldn't have been able to put on this fabulous webinar.
Thank you very much, everyone. This concludes today's webinar. In approximately 2 to 3 business days following the webinar, we will send out a link of the webinar recording and access to the PowerPoint materials. Thank you for attending.